Hey guys, attorney Marc Victor here with the Attorneys for Freedom Law Firm. And we get questions from time to time from people regarding gun issues and what they can do and what they can't do. So sometimes we cut videos just to address questions that we get on a regular basis so we can get some answers out there. And today I've got a question that really deals with the issue of storage lockers and how alcohol and places that serve alcohol sort of fit into the analysis. And some of this is some tough sledding, but I'm going to try to simplify it down and make it easy to understand. So here's question one. Many Arizona gun owners think a private business that bans firearms is required to provide storage lockers. Is this true? Well, this is an easy one. Answer, no. A private business that's just engaging in private activity is never required to have a storage locker for people to enter and check their firearms. It just doesn't apply to private businesses. So the answer to that one's a real easy one. Second one, many Arizona gun owners believe that if a public building doesn't offer storage lockers, they can simply ignore a sign banning guns. Is this true? Answer, no. But I want to give a little bit more detail here as well, because I think in order to understand this area of the law, you need to understand two definitions that are important. First, public establishment. What's a public establishment? A public establishment is, in essence, these are simplified definitions, but it's a building or a vehicle that's owned by the government or some political subdivision of the government, maybe a city or a county or the state. That's a public establishment, either the building or the vehicle owned and operated by the government. A public event. This is a little bit trickier. A public event is basically either an event that is run by the government or a political subdivision, or, this is the part that gets a tad bit tricky, or a public event is run by a private entity, but that private entity, in order to run that event, needed to obtain either a permit or a license from the government to run the event. Now, excluded from this definition is the liquor license. So if you have a liquor license situation, that's outside the definition here. Why am I telling you about these two definitions, public establishment and public event? Because these are the two areas that the law does say they're required in that event. If you are either a public establishment or running a public event, which remember is either run by the government or run by a private entity that needs a permit or a license, that's not a liquor license. If you're one of those two things, then yes, they are required to provide storage lockers. So that's really important to know if you're dealing with a public building or a private event with a permit that's not an alcohol permit. There are supposed to be ways to check your firearm at the door. All right, so let's keep going here. Let me get to question three, and it'll tie some of this up together. So question three, regarding signage requirements for places that serve alcohol, is this reasonable notice that no guns are permitted, such that it wouldn't be a trespass if the person entered with a firearm? The answer is yes, it would be a trespass. Now, keep in mind, there are many different requirements, and some of the more astute gun owners who like to read the statutes will say, hey, Mark, there's a whole bunch of requirements for these places to have these guns these signs that prohibit guns, and if they don't do that right, well, then the sign is not effective notice. Look, we don't have a lot of case law here, but I will tell you, let me make it simple for you. Do not bring your gun to a place that serves alcohol unless you have a concealed weapons permit and there's no sign at all that says anything about banning guns. Because I recognize that although all of the sign requirements in the statute, and I understand that there are sign requirements in the statute, and if they're not followed, that those sections may not apply. I also understand that Title 4229 and 4244, Section 29, are a bit in conflict here for those of you who like to read the statutes. However, it's my reading of this that what you should be concerned about is not the misconduct with weapons crime that's listed in that statute, but instead the trespass section. because the misconduct with weapons section, if you violate that on these points that I've been discussing, is a misdemeanor. If you violate the trespass statute, that could easily be a felony. And so I want you to be careful about the trespass statute. And so let me break it down and just say this. If you're on notice that the owner of that property or the person who's in control of that property, by any means, by the sign listed in the misconduct with weapons statute, or any other sign, or even verbal notice, even if the manager comes and says, hey, sorry, no guns in here, you need to leave, you're on notice. That's reasonable notice. And irrespective, regardless of anything in that misconduct with weapons statute, don't commit the trespass. Keep in mind, this is sort of an anti-freedom position to begin with. Entering somebody's private property who doesn't want you to enter with a gun. If you violate that, you're not respecting this person's private property. So don't do that. So regarding the last thing I wanted to say with alcohol is absolutely don't drink any alcohol if you're possessing a firearm. And I shouldn't even have to say this, right? If you got a gun, don't drink any alcohol. Don't even possess the alcohol. Very bad idea. And keep in mind, this doesn't just apply to alcohol. I'm talking about any drug whatsoever that impairs your judgment. Do not ingest that drug if indeed you are possessing a firearm. So I hope that clarifies things. I also want to mention, if you are indeed a gun owner and you are in the state of Arizona, you really ought to be a member of our Attorneys on Retainer program. You can find out lots of information about it by just simply going to the Attorneys for Freedom website. Up at the top, click on the red AOR, Attorneys on Retainer button. You'll see information there about the self-protection plan. This is for gun owners. If you're a gun owner and you're a member of the self-protection plan, which is going to cost you $25 a month, and you get charged with any of the listed crimes, which are all of the crimes that, in my experience of the last 26 years, representing gun owners in gun crimes, these are the things you're likely to be charged with. If you get charged with any of those, no worries for you about attorney's fees, because your attorney's fees are covered 100% even through a jury trial. Yeah, for $25 a month. If you also are interested in coverage beyond the area I just explained, check out the standard option. This covers you on any crime you get charged with. You pay $175 an hour across the board through trial. That's what your attorney's fees are limited to. And this also covers you in almost the entire universe of civil cases as well. So if you get sued, or you're going to sue somebody, or you have a civil rights case, or anything along those lines, $175 an hour, or a reduced contingency fee. By the way, you can get both packages, the self-protection and the standard option, and what we call the bundled option. It's $40 a month. You get both programs. It's excellent coverage. So I hope you check into the Attorneys on Retainer program. If you have questions for me about anything I've discussed here today, then certainly get a hold of me through the website, attorneysforfreedom.com, or just send me an email directly. It's Marc, M-A-R-C, at Attorneys for Freedom. That's attorneysforfreedom.com. Thanks for listening.